everyone. I'm Judge Jackie Powell, and this is First Appearance Court. Today, I'll let you know if I've determined probable cause, and then we will also talk about release conditions. Today's not your trial date, and so I encourage you to speak with your attorney before speaking on the record. Everything in this courtroom is being recorded and can be used against you at a later time. For those of you who are represented by the Public Defender's Office in the courtroom, I do have Attorney Brian Reedy with me, and over at the main jail, Mr. Hector Romero. And these attorneys are available to all other persons who are at the other three facilities, Paul Ryan, Conti, and North Broward. For those of you who are represented by private counsel, these attorneys do come to the courtroom. And if your attorney's not here, if you have a private counsel and the attorney's not here, you can let me know and I will try to make a phone call to see if we can locate your attorney. But please don't tell me that you have private counsel if you or your family did not retain the attorney for this arrest. Just note that because an attorney has represented you in the past, or maybe is representing you on a pending matter, does not automatically mean that they are representing you on a new case unless you have retained them for that matter. Also in the courtroom with me, I have the attorney from the State Attorney's Office, Mr. Eric Linder, as well as I have representatives from confinement status, pretrial supervision, the clerk of courts. All these persons are here to help with this morning's hearing. For some of you charged with misdemeanors or municipal ordinance violations, you may be able to resolve your case here at first appearance. But just note that those of you facing felony charges, or if there's a violation of probation where the judge has already signed a no bond warrant, those you have to go before your division judge to resolve. All right? There is a few persons that we have signed in, and also Mr. Reedy. Is there anyone from the main jail or from any of the jail facilities that they've asked to call out of turn?
No, Your Honor.
All right. There's one case that I need to call Charmaine Wade. That's a case on page 3.
Page 3, let me check.
She's where?
North Broward.
North Broward? All right. Good morning, Ms. Wade. The state has some information on your case.
Your Honor, I'm going to ask that the court ROR Ms. Wade a brief explanation. As you can see, Pembroke Pines previously issued an arrest warrant for grand theft. They were unable to serve the warrant. They provided the paperwork to my office. The case filer made a filing decision and filed it as a petty theft.
Okay.
Ultimately, an issue summons was issued. She's appeared in court on that for a Raymond N. calendar call. I don't know why or how it happened, but this warrant should have been taken out of the system, wasn't taken out of the system. She should be immediately ROR'd, Your Honor.
All right. Ms. Wade, I'm sorry that you had to go through that, but
Yes, because I was attacked by a lady yesterday in a holding cell, and I had to be put in the hospital. You see what she did to my face and my lip? I have stitches in my face right now because the lady beat me up.
Ms. Wade, I'm not going to be able to get a photographer out to see you before you get released. So make sure that you or someone you know takes photographs of your injuries, okay?
Yes.
all right, good.
You were right about what you told me about your case, so.
All right, take care, ma'am.
Thank you.
All right. All right, on page 1, Shelley Macias. Good morning.
Michael Salazar on behalf of Ms. Macias.
Where is she? What?
Paul Ryan, Judge.
Paul Ryan.
Paul Ryan.
Morning.
Just to let you know,
Good morning, Ms. Macias.
both
Good
Mr.
morning.
both Mr. and Mrs. Macias are here, the alleged victims. So, Judge, I've read the probable cause affidavit, and we're asking if you would allow Ms. Macias to be ROR'd. If I may proffer what the two alleged victims would want to ask you is that they're going to tell you this stems out of a drinking problem. So they're willing to have no contact with Ms. Macias, Shelley Macias, up until she finishes 4 weeks at Blue Water Recovery Sober Living. They're willing to pay 4 weeks at this residential place for her to get alcohol treatment. After she finishes the 4 weeks, they're willing to have contact with Ms. Macias.
Well, how is she going to get to that facility?
Apparently, she has a close friend that's willing to take her to that
Is
facility.
is the person going to pick her up from the jail to take her to that facility?
That I don't know, but could you give me one moment, Judge?
If I could, as far as contact, if I could address that first, I'm gonna ask the court to impose no contact this time because she's just here on the ad charges. She was before Judge McHugh, I believe yesterday or the day before, for a kind of misdemeanor battery. And, Ms. Macias was the listed victim in that case, but I'm looking, Judge McHugh already issued a no contact order with both parties that are the listed victims of this case. So she's gonna have to go.
So Shelley Macias was the victim in the other
No, no,
case?
no, no, no.
You said Miss Macias.
And I was,
You mean the
I'm
mother?
sorry, I should have been more specific. I was, Araceli. Macias.
Okay, okay.
But the no contact order also lists,
Neville Macias.
Neville Macias. So since there's already a no contact, obviously, in those 4 weeks, Mr. Salazar could go before Judge McHugh, Judge Allspec, and seek modification. But because there's just a blanket no contact order at this time for uniformity, I would ask that the court issue no contact in this matter.
Are there, does she have any priors?
The only thing I see, Your Honor, in the notes is there was a previous Marchman Act. And I can tell you, the Judge McHugh said $1,000 bond that's already been posted on count one. I guess what happened was the arresting officer might not have realized at the time or wasn't thinking as far as the elements of the crime, the victim's age. So she was one count for Araceli Macias based on her age, and then add charge involving Neville Macias, basically.
All right, well, I did note that the both of them indicated through the police officer that they did not wish to prosecute.
That is still correct.
I read that in the probable cause affidavit. But I am not going to lift the no contact order because that's going to be a conflict. One judge has already listed a no contact order. All right, and so she has $1,000 bond, and what I'll do is I'll ROR her on 2 and 3. She's already posted that bond on number 1.
I believe so, yes, Judge.
That's what the system
All right,
indicates.
and so no victim contact, and I'm going to put that in place as well, and it is the same, no victim contact that Judge McHugh placed. I'm sure no phone calls, no text messages, no social media, no third-party contact until that order is lifted by a judge. Okay?
Thank you, Judge.
Okay.
Can I ask a question?
Your attorney's there, I guess,
Not at this time, Ms. Macias. I'll come see you at the jail unless you get bonded out. Then we can talk over the weekend.
Okay,
Thank you, Judge.
thank you. Is that it?
yes, ma'am.
Thank you.
Lamar Mitchell? Okay. Jerrell Howard on page 12.
Jarrell Howard, Judge, what's your name? Oh, this is Lamar Mitchell, Judge. I didn't know who.
We
you
have to
called.
recall Mr. Mitchell. His attorney needs a little time to. So Jerrell Howard now.
Yes, ma'am.
All right, Mr. Howard is before the court on charge 1 on a battery on a officer or firefighter. And I find probable cause.
And, Your Honor, as you see, Mr. Jones is here. I spoke with him before court.
Yes.
Just to get some insight as to what the family can afford. What I discussed with him, based on I don't see any significant history. Based on the level of violence alleged, I asked if he believed the family could afford a $1,500 bond. He advised me he did believe the family could afford that bond.
All right. All right, so I find probable cause and I'll impose a $1,500 bond.
The only other thing I'm gonna ask, Your Honor,
Yes.
James, as far as you know, he doesn't live there,
You can ask him. I'm
right?
not sure.
Hector, does he live where this occurred?
So
I
it
see
says
a
something about
Margate
us.
address and this happened in Lauderhill.
No, you don't.
Then I just asked no
I don't know
return.
the incident location, but he's, advised me, no, he does not.
Okay, just because this involves a security guard for this neighborhood, I would just ask for an order of no return, Your Honor.
All right, so no return to this location, sir. Do you understand that?
Yes, ma'am.
Okay,
Thank you, Judge.
all right.
Thank you, Your Honor.
You're welcome. All right, Mr. Shade. On page 2, Darlene Garand.
No problem.
All right, Ms. Garand is before the court on a misdemeanor KPS. This is from September 23 of this year. You didn't show up for arraignment on an alcoholic beverage violation. What do you want to do today, ma'am? I find probable cause. Your options are, you have a $250 bond, you can post the bond, or you can remain in custody until Monday when you will see your division judge, or you may resolve your case today if there's an offer from the city.
There's an offer from the city judge, it's time served.
And there is an offer from the city for adjudication and time served. What do you want to do?
Yes, time served.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes,
All right, you can put your hand down. And do you understand the offer that has been extended to you?
yes,
Is anyone forcing you to resolve your case?
no,
Are you under the influence of drugs or alcohol?
no, ma'am,
Do you need any more time to speak with your attorney?
no, ma'am,
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
yes, ma'am,
Have you ever been treated for mental or emotional illness?
no, ma'am,
And do you understand, ma'am, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
yes, ma'am,
What plea do you wish to enter at this time, guilty or no contest?
no contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, adjudication, time served. Good luck.
Thank you, ma'am.
All right, you're welcome. On page 2, Christina Smith.
Can we reset her for tomorrow, John?
Okay, all right.
Thank you.
Reset. On page 9, Elvis Ford.
No problem.
All right, Mr. Ford is before the court this morning. One charge of, it's a misdemeanor KPS. And it's a KPS that was issued August of this year for, it looks like soliciting without permit. And what do you want to do today, Mr. Ford? I find probable cause.
It's a time served, Judge.
The city is offering you time served to resolve the case. Do you wish to accept that?
I'd like to resolve it.
All right, please raise your right hand, Mr. Ford. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. And do you understand the offer that has been extended to you?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter at this time, guilty or no contest?
No contest?
I accept your no contest plea. I find that it's freely and voluntarily given, and your sentence, Mr. Ford, is adjudication, time served. Good luck, sir. Page 9, Mervyn Luster.
Mr. Luster, come on up, please. Marvin Luster? You page 9 says Maine. 4A. Mervyn Luster. One moment, Judge.
Sure.
He's in back? Okay. Judge, he's going to be coming right in.
All right. Is Dominic Butler there while we're waiting?
Mr. Who?
Dominic Butler on page 10.
Mr. Butler, come on. He is.
Okay.
Good morning.
Good morning, Mr. Butler. You're before the court on a KPS. It's a misdemeanor KPS. You didn't show up for court on October 21, and so what do you want to do today? The charge is possession of drug paraphernalia. There's an offer from the city. It's a city ordinance violation, so the city's offering time served. Do you wish to accept that?
Yes.
All right, please raise your right hand, Mr. Butler.
Municipal?
Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. And Mr. Butler, do you understand the offer that has been extended to you?
Like partially.
It's a time
Like,
served.
what do you mean?
It's time
What do you mean
served.
by time served?
You'd be getting out this afternoon.
Oh, okay. Yes, I understand.
All right, and is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, thank you.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time, Mr. Butler? Guilty or no contest?
No contest?
I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence serves adjudication, time served. Okay?
Okay, thank you.
And then, do we have Mervyn Luster now?
Yes, Judge. He's coming up. Come on up, sir. Go see the judge.
All right, Mr. Luster, you have a KPS on a municipal ordinance violation for an open container charge. Mr. Luster, do you wish to resolve your case today?
Yes.
Is it, Deerfield, is time served? All right, Mr. Luster, if you wish to resolve your case today, it'll be time served. The case will be over today, and you'll be out later today if there's nothing else holding you in custody. So do you wish to do that at this time?
Yes.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down, sir. And is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, Mr. Luster, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, guilty or no contest?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given. Your sentence, adjudication, time served, right? We're doing 6 months on the court costs, right? Okay,
Thank you, Judge.
all right. You too. All right, on page 18 then, are we ready to address Lamar Mitchell?
Yes, sir. Good morning.
Good morning.
Yes, Honorable Court. Gawain Grant representing Mr. Lamar Mitchell.
All right, so Mr. Mitchell is before the court on charge 1, burglary, unoccupied dwelling, unarmed. Number 2 is a out-of-state felony hold, which is a no bond hold for New York. And then number 3 just looking again for, number 3 is an immigration hold. See the bench warrant, I don't have a detainer for the immigration hold.
Your Honor, while it's being addressed, I spoke with Mr. Grant.
Yes.
Count 1 is actually a burglary conveyance.
Burglary of a conveyance, okay?
And if it's acceptable to the court, we discuss the matter. Based on the other holds, Your Honor, we've agreed to a $3,000 bond.
Okay. All right, confinement, do you have an immigration hold detainer? Okay. All right, so, there's also the immigration hold, Mr. Mitchell. It is a no bond hold for the Department of Homeland Security. You'll have to go before an immigration judge on that one, but based on the agreement between your attorney and the state, $3,500? Was it 3,500?
No, it's 3,000.
3,000? All right, so $3,000 bond on one,
Good seeing
okay?
you, Judge. Thank you.
Same here. All right, Steve Nancy. Nancy Steve. Miss Steve bonded? No? This is an ad charge. She posted bond on the other. Do we have Nancy Steve? She posted the bond?
She's at the courthouse this morning, Your Honor.
All right, so question, confinement, did she post bond on this number 3? Okay. All right, thank you, Deputy. All right, Molly Provo.
No problem.
All right, Ms. Provo is before the court on one charge of resisting officer without violence, and I find probable cause.
Your Honor, Ms. Provo indicated to me that she has never been arrested anywhere before. In light of that, and she does have ties to the community, I would ask the court to consider releasing her on her own recognizance.
Respectfully, I would ask to inquire what those ties are. I do see the booking sheet shows an at-large address.
Has this been a reset from?
It was reset
It was
from
reset
yesterday.
from
Okay,
yesterday.
all right.
That's correct, Judge.
And I can tell you, Judge, she was referred to Judge Lerner Wren.
I know we've talked about these referrals in the past. We've taken pleas on people who have been on that list. I know that that list does not address issues of competency. Based on my conversation with Ms. Provo, I didn't have any problems communicating with her whatsoever. Where are you going to be staying, Ms. Provo?
I'm trying to get into rehab.
reports her release advising she has ties to the community, and that sounds good, but without knowing what those ties are.
Well, when you read the probable cause affidavit, there are concerns. She did not have an ID. She wouldn't give her information. She wouldn't respond to law enforcement. And then when they asked her name, she said, "I don't know, just arrest me, I will have a place to stay." And the allegations, well, it all started with her going into Denny's, ordering food, and then not paying for it. So there's more things going on here. And so if there is a referral to Judge Lerner Renzovision, I am going to, based on what I've read this morning, I am going to grant that and sign the order to transfer the case to Judge Lerner Renzovision. All right?
All right, Molly, you'll see Judge Lerner Wren next week, okay?
Okay. Am I done?
Yes, ma'am.
Yeah.
Faye Coswell?
Jermaine?
Ms. Coswell is before the court on one charge of trespassing, unoccupied structure or conveyance, and I find probable cause.
Judge, in speaking with Ms. Conswell earlier today, she wishes to resolve this matter.
Your Honor, yeah, I see she has 2 pending cases right now in front of Judge Lerner Wren. Frankly, I don't know. It says MS, but then I saw a note that making reference that it's an MI. One of those, the history of her cases, she was arrested for a trespass at this location. She was given pretrial. She then did not appear to pretrial. Judge Lerner Wren revoked her pretrial. She then got arrested on a resisting without violence and a capias on the trespass, and she was ROR'd again on those.
Right, I do, it is recorded in the probable cause affidavit that these actions occurred previously. She entered and remained in the property, having full knowledge that she was not to return or face arrest. She was very uncooperative on the scene, stated several times on scene that she would not be leaving her own home. She could not show any proof of ownership for the residence and became very aggressive with officers when we asked her to remove her bags. Again, this is reflective of there's something else going on there. I will sign an order to transfer to Judge Lerner Renzovision, okay?
And Judge, I understand the court's concerns, but Ms. Conswell advised me. I see the bond's only $25, but she indicates she can't afford it. Would you consider releasing her under supervision?
No, I'm going to deny that at this time. Akia Mosley,
She's approaching, Judge.
all right, Ms. Mosley is before the court for 2 charges of use of false ID adversely affecting another, and I find probable cause for these charges.
Judge, the problem is I don't believe, and she does not believe that her phone is charged, so she doesn't think she can call anyone to post her bond. Now, my understanding is she has very, very limited contact with the criminal justice system. She's been here her whole entire life. She's 39. She's looking for employment at this time. She just moved into a residence in Fort Lauderdale with a roommate. So we're asking the state to confirm that she has basically very limited contact with the criminal justice system, if the court would consider releasing her ROR, or in the alternative, releasing her under supervision of pretrial release.
Your Honor, she does have a limited history. I'd be asking for pretrial only because, based on the nature of these offenses, it's hard to have full confidence on someone who's allegedly using her sister's identification to avoid arrest and criminal consequences.
Right, and what's also noted is that it happened twice in the same day. The law enforcement she just happened to come in contact with the same officer doing the same thing twice in the same day. All right, I'll ROR her to pretrial supervision, and so Ms. Mosley, you need to report to the pretrial office. Today is Friday. If you don't get out on time today, by Monday morning, you're at the main jail. The pretrial office is right across the street. If you don't report, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right. All right, we have the Spanish interpreter. Who needed the Spanish
Judge, there's
interpreter?
one person that requires attention to her here at Maine, and he is on page 12 of the court's docket. His name is Mr. Gustavo Lopez. Senor Lopez.
All right. All right, if you'll raise your right hand, you swear affirm to interpret from Spanish to English and English to Spanish?
I do. Esteban Rojas.
Morning, Mr. Rojas.
Morning.
All right, Gustavo Lopez.
Señor Gustavo López.
Mr. Lopez, you're before the court. Charge one is an out-of-county misdemeanor hold.
Señor López, usted está compareciendo ante este tribunal por el primer cargo, que es una orden de captura desde fuera del condado.
And that's not from magistrate, it's for St. Lucie County.
Y eso no es para este tribunal, es para el condado de St. Lucie.
Number two is an immigration hold.
El segundo motivo por el cual está acá es una orden de captura de migración.
And I've reviewed the detainer from Homeland Security.
Y ya he evaluado la orden que proviene del Departamento de Homeland Security.
And I find probable cause.
Considero que existen indicios probables.
This has a no bond hold and you'll have to appear before an immigration judge on that charge.
Y esta es una orden de detención que no permite la posibilidad de fianza y usted tendrá que comparecer ante un juez de migración.
All right. Is there anyone else who needs a Spanish interpreter?
No one else at Maine, Judge.
All right, hearing nothing, thank you. Antoniqua Lovis.
Been informed she bonded, Judge?
All right, Ms. Lovis bonded. I find probable cause. Lanisha Bullard.
North Broward, I believe.
She's a medical reset, Your Honor.
All right, Ms. Bullard is a medical reset. Thank you. Hattie Jackson.
All around, Your Honor.
All right, Ms. Jackson is before the court on, these are some additional charges. So charge number 9 is larceny, $300 less than $10,000 from a 65-year-old victim or older. Number 10 is illegal use of credit card more than 2 times in 5 months. Number 11, fraud, use or possessing ID of another person without consent. 12 and 13 are a violation of felony probation. And it looks like you are on probation with Judge Garcia Wood. No bond warrant was issued, so you have a no bond hold on those 2 violation of probation. You'll see Judge Garcia Wood on November 23rd, it says, at 8:30 a.m.
Good luck, Hattie.
Thank you.
All right, I find probable cause, and I will leave the bonds in place. Okay. Jessica Steffi.
Good morning, ma'am.
Good morning. Ms. Steffi is before the court. Charge 1 is burglary, occupied conveyance unarmed. Number 2, possession of harmful new legend drug without a prescription. Number 3, 4, and 5, possession of drug paraphernalia. And number 6, touch or strike battery. I find probable cause. And I'll hear from the parties as to Ms. Steffi.
Your Honor, I'm going to be seeking a $10,000 bond on count 1, no victim contact. My concern with the allegations, obviously, is that Ms. Steffi, it's not that she just broke into a car. She broke into a car while it was occupied by the owner, who happened to have her 4-week-old baby in the back seat. Ms. Steffi also has criminal history, 2015 possession of cocaine, 2015 possession of cocaine, 2003 possession of cocaine, the violation of probation, possession of cocaine 99, 98, 98, burglary of dwelling 95, possession of cocaine 95.
Okay.
Believe there's any way Miss Steffi is going to make that amount of bond. She has been a resident of South Florida since she was 12 years old. She does have some priors. She lives with her mother. She's had a job working as a server at IHOP for the last 10 years. She makes about $1,600 a month, and she pays her mother $400 a month. Also, she takes care of her mother, who is frail and needs her assistance to get around. She just got a new car, but I don't think she's going to be able to make a bond anywhere near that high, Judge. I'd ask for a $2,500 bond.
All the things that you've just told me about Ms. Steffi does not line up with anything that's in this probable cause affidavit. She has a job, she has a new car, she's taking care of her mother, and the allegations are that this person is putting her child in her car. So while she's in the back putting the child in, she goes and takes the wallet from the front. The husband comes out and confronts her, and she takes off with the wallet.
Which I returned, right?
Don't say anything
Right,
about the facts of the case, Miss
which
Steffi.
the allegations say that you dropped the $60 cash on the wallet on the ground when you were being confronted by the other person. And these items were recovered by the other person. They followed the suspect into the parking lot and then into Publix. So it doesn't line up. So at this time, I am going to impose on charge number one, a $10,000 bond and no victim contact. And,
Is there any way you can get pretrial, ma'am?
no, ma'am,
Why?
not at this time, based on everything that I just said a moment, that's why.
You know, I have been in recovery.
I'm done. Shanquinetta Cherry? Where's Shanquinetta Cherry?
Is she a reset again? Is she?
It's a
Judge, I've been
reset?
advised she's at Paul Ryan. That's what the deputies Monday.
Shanquinetta Cherry? Is that? No?
There's got to be a deputy in the room.
Deputy Paul Ryan?
Yeah, but they're not going to leave that by himself.
Yes, ma'am.
Shanquetta, last name Cherry.
I'm sorry, my doctor shows her being at main jail.
Okay,
I'll look right now if she's there, okay?
all right. You let me know. I'll go on
Yes,
and then
ma'am.
you'll let me know. Thank you.
Yes, ma'am.
All right, do we have Ebony McLemore today?
She's in downtown. She went downtown for it.
All right. Jacob Missick?
Conti, Your Honor.
Me.
They sent him down to domestic violence court this morning.
And they brought him here to get.
Oh, is that the main jail now?
Instead
Okay.
of
It's a Friday.
All right, so Mr. Missick is before the court on two ad charges. Charge number 4, carjacking without a firearm or weapon, and number 5, battery causing bodily harm. All right, and I find probable cause.
Your Honor, I'm going to be requesting a, excuse me, a $25,000 bond on count 4, the first-degree felony, and an order of no victim contact. I'm sorry, $5,000 bond in order of no victim contact. He's being held no bond right now on a violation of community control for grand theft auto. Charge 1 is leaving the scene of a crash.
And Judge, and speaking to Mr. Missick, from what he advised me, this came to his surprise. He doesn't know regarding these allegations. First, he wanted to know when was the alleged date of incident on these allegations, and who was the alleged victim.
October 8th, 2019, victim Sarita Latoya McGee. There's an incident that occurred while they were driving in a car. And, yes. There's allegations that he hit her in the face and on the body. And then when they got to Checkers, she tried to get out. He continued to strike her. And then he managed to lock the door and kept her inside. When she was about to open the driver door and kicked it open with her foot, and then she fell out of the vehicle. Then there was a struggle. She was screaming for help, and then a third party saw the commotion and called 911.
And Judge, as Mr. Lender said, he's currently in custody, being held no bond on violation of probation. I believe he's been in custody now for 33 days. His next court date is on the 17th of December, but before he was incarcerated, he wasn't working, so his financial resources are limited, so I'm asking you to take that into account in determining reasonable release conditions for Mr. Missick.
All right,
Your Honor? And
yes.
just also to let you know about his history. 2018 aggravated battery against a pregnant victim and domestic violence battery by strangulation. He was qualified as a habitual offender in that case. Grand theft auto 2018, burglary of a dwelling, grand theft 2014. He was arrested for battery in 2014, that was dropped. False imprisonment and battery 2013, strong arm robbery 09.
All right, 25,000 on number 4, 5,000 on number 5. No victim contact, and that means no phone calls, no text messages, no social media, no third-party contact.
Your Honor, Paul Ryan, facility.
All right,
Yes, Your Honor.
yes.
Mr. Cherry informed me that, well, let's say kindly, she did not wish to join us today.
Okay, well, I will reset Ms. Cherry for tomorrow, and then we will see what happens, okay?
Yes, yes, ma'am.
Thank you so much, Deputy.
You're welcome.
Maurice Moss.
Mr. Moss is here, present, Judge at hand. Come on up, Mr. Moss.
All right, Mr. Moss is before the court. Charge 1 is a traffic KPS. I have no information on that KPS.
Sheila, was that already handled, or, because I didn't see.
Even though I know it's not, but I have.
No, I know, that's why I was curious. If he'd already had his first appearance on that, or, fine.
So he's already resolved the KPS matter, the traffic KPS, okay? All right, and so number 2 is aggravated battery causing bodily harm, domestic. Number 3 is domestic battery by strangulation, and I find probable cause.
Just pulling his history, if any. Okay. 2016 grand theft, 2015 strong arm robbery, aggravated stalking, violating an injunction. He was arrested for battery in 2015, that was dropped. He was arrested twice in 2015 on domestic battery charges. One was an aggravated battery, great bodily harm, and domestic violence battery by strangulation. Charges were dropped. The other was aggravated assault with deadly weapon and felony battery due to priors. That was dropped. 2013, 2 grand thefts, felony theft in 2013. grand theft 2012. In 1999, he was convicted of aggravated battery and battery, 35-month state prison. 98, burglary of an occupied conveyance and 2 counts of battery of EOP, 34-month state prison. Based on his criminal history involving violence, Your Honor, the state would be requesting a $10,000 bond on each count, no victim contact.
Judge, and speaking for Moss, he's not going to be able to afford $20,000. Now, my understanding, I do not believe this incident is recent. He's 44 years old, been living here his whole entire life. He's self-employed. He installs windows and doors for a living. I did advise him, though, that due to this being domestic, the court's going to order no contact. He will be abiding by that order. He'll be living separate and apart. He'll go to reside with his mother, who resides in Margate. My understanding is she is retired, so her funds are limited. Now, I believe since the incident date, Mr. Moss and the alleged victim have reconciled. In fact, I believe the victim is probably going to go to the state attorney's office and maybe sign a waiver of prosecution. Having said that, Judge, I'm going to be requesting a $5,000 bond on count 2 and a $5,000 bond on count 3.
Well, you know what I said, she's probably, or she's maybe gonna go to the state attorney's office. This incident occurred October 5, and she's had over a month to do that, if that's what her intentions are. The allegations that I have here is that she was struck with a combination of open hand and closed fist strikes over to her face and head. Defendant used a wooden paddle and a bathroom digital scale made of glass to continue striking the victim, causing the scale to break and shatter. During defendant's physical attack on the victim, he used his hands to begin choking the victim, impeding her ability to breathe. The defendant's actions caused injuries to the victim's left side of her head, where she sustained a contusion and abrasions to her left eye. And there is pending medical assessment as to whether there is permanent damage. Right? So those are the allegations that I have, and so based on these allegations, I am going to impose $10,000 bond, charges 2 and 3, no victim contact, and that means no phone calls, no text messages, no social media, no third-party contact, until further order of the court. Jeremiah McWilliams.
Mr. McWilliams is approaching, Judge. I asked him, my colleague asked him. He's not applying with the public defender's office. He's representing himself. Hello, ma'am.
All right, good morning, Mr. McWilliams. You're before the court on one charge of aggravated battery. Offender knew or should have known that the victim is pregnant. I find probable cause. All right, I'll hear from the state at this time.
What was that, ma'am?
I'm waiting on the prosecutor to tell me what if they have anything to say.
Your Honor, Mr. McWilliams has no criminal history. Based on the allegations in this case, I am going to be requesting a $7,500 bond and no victim contact.
I'd like to request to be placed on pretrial because no one's going to pay that for me.
All right, these allegations are that defendant used his left forearm to push the victim against the wall at chest level. She stated that his arm began to come further upwards toward her neck, at which point she grabbed his forearm out of fear and pushed him away. It was at that point that the victim locked herself in a bedroom and called 911. She stated that the defendant began breaking and throwing things in the house before breaking down the door just prior to police arriving. The victim and defendant have been dating for over 2 years. Victim is 5 months pregnant with the defendant's child. Officers took pictures of the damage to the house, which included a hole in the bedroom door, broken mirror in the bedroom, and a broken window in the bedroom. All right, finding probable cause, I am going to impose a $10,000 bond, no victim contact. Sir, that means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, sir?
Yes.
Okay.
Can I be released on pre-trial basis?
I'm denying that, sir.
Alright.
All right, Duval Constant,
He's approaching, Judge.
Christian Constant Duval. Good morning, sir. Mr. Duval is before the court. Charge 1 is missile into a dwelling or vehicle, or number 2 is criminal mischief. This is an incident that occurred back in March of this year, and I find probable cause.
Your Honor, I'm going to be requesting a $5,000 bond, no victim contact on count 1. He has a theft out of date from 2015. Battery on a law enforcement officer, resisting an officer with violence and criminal mischief, 2010 out of Dade County. Carrying concealed firearm, 3 counts, 2013 out of Dade County. There was an arrest in 2012 for 2 counts of battery. They were both dropped. And another arrest in 2015 for battery in Dade, that was dropped. And another arrest for battery in 2015 in Dade, and that was dropped as well. Nothing further, Judge.
Okay.
Yeah, Judge, as the court pointed out, this incident happened back in March. I believe the incident was in Hollywood. Since then, my understanding, Mr. Constant does not live around there. He lives with his mother, residing in Miami. His mother is retired. That's the person he's going to be counting on to help post his bond, as well as his father. And my understanding, his father works at the flea market. He's 28 years old, been here his whole entire life. So based on his mostly his father's financial resources, he believes using the service of bondsman, he can maybe come up with $3,000. So that's why we're requesting $3,000 bond on Mr. Constant Duval's behalf, Judge.
Why is this, why does it say no bond on number 4? That's incorrect, right?
Yeah, it should be, it should be hold for magistrate, I believe. Right, Sheila? One moment, Judge. Let me pull up the KPs. No, I'm looking at the KPs. They're both hold for magistrate.
Okay. All right, so based on these allegations, which are that he not only threw a rock through the windshield, a large piece of cement through the victim's car. There's also that he threw something through the window of the house, that he broke the glass of the living room door with large pieces of cement that were found on the living room floor. This all the while, the alleged victim was at home with her minor child. I am going to impose $5,000 bond on 1, $5,000 bond on 2, and no victim contact. And, no, you need, no, please come back. Because, there are allegations that they're no longer living together and that, he doesn't live in the house. He told her that he would kill her if, there's a vehicle that's parked at the house that she said she's not allowed to have at the house because he doesn't live there. The landlord told her that he needs to move the car. When she told him that he had to move the car, that's when he told her if she touches the car, he's gonna kill her. Then after that, he comes to the house through, so if Mr. Duval posts his bond, he's also going to be on a level 2 pretrial supervision. All right, Pierre Morose. Mr. Morose is before the court, one charge of loitering or prowling, and I find probable cause.
Judge, Mr. Morose wishes to resolve this matter today.
All right, the state of an offer.
One moment, Your Honor. I need a moment, I'm looking for the paperwork. So you're talking. Your Honor, I apologize. Oh, here it is. Okay, sorry. The offer would be adjudication time served. No return.
Mr. Morose, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, sir, you can put your hand down. And do you understand the offer that has been extended to you, sir?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter at this time? Guilty or no contest?
No contest.
I accept your no contest plea, find that it's freely and voluntarily given. Your sentence, sir, adjudication time served. Good luck. Patrick Todd.
Mr. Todd, come on up, please. Who's approaching, Judge? Me?
Mr. Todd is before the court on one charge of exposing sex organs in public, and I find probable cause.
Judge, Mr. Todd is homeless. He gets disability. From what he advised me, well, I'm asking the court to take that into consideration.
Sure.
Your Honor,
Yes.
I'm going to be asking for a bond increase to $5,000. I'm showing that Mr. Todd has a warrant out of the state of New Jersey from August 4th, 2017 for sexual exploitation of a minor, photographic material. Additionally, 2016 out of Broward County, aggravated assault with deadly weapon with the violation of probation. He was sentenced to 270 days county jail. I'm also showing, where did you see aggravated assault? Yeah, but where did you see a warrant for aggravated assault? That's what I did. He was arrested in the state of Georgia in 2016 on a fugitive warrant, and that was for the Broward County warrant from his, for what offense? That was the aggravated assault. That's for the case I told the judge about.
Okay,
Judge, I'm also gonna be asking for a medical screening.
all right, so I am going to impose a $20,000 bond. I'll sign an order for the medical screening. Okay. Kevin Crone,
20.
Mr. Crone, come on up, please.
yes. Kevin Crone is before the court on a trespassing charge, and I find probable cause.
Judge, in speaking with Mr. Crone, we're gonna be asking the court to consider releasing an ROR, or in the alternative, pretrial release. Right, he's 62 years old, been here since 1957. He's a handyman by trade. Unfortunately, business isn't going that well. The last time we got paid was about 2 weeks ago, only $200. So at this time, considering this a nonviolent offense, Judge, I'm asking for an ROR and the alternative, pretrial release.
I'm always going to ask a question where it appears that there would have not been an arrest if you'd have just left. Defendant does not live at the address, and he was asked to leave the property multiple times and refused to leave. Those are the allegations. It seems like all of this could have been avoided.
Honor, can we approach?
Okay? Are we going off the record? Because you, okay. All right, okay, folks, I find probable cause, and he has a $25 bond, and I am going to transfer the matter to Judge Lerner Rencivision as well. Okay, I'll sign an order doing that. That's based on my conversation with the defense and state. All right, Mr. Nichols, are you ready to address your case? Yes, ma'am. All right.
Hi, Judge.
Morning.
This is on page 17, Pierre D. Tarnowski.
Mr. Detornowski, come on up. Your private counsel is there in court.
Your Honor, if we could put this on a brief recall, Mr. Griffith from my office is here to run through the courtroom. I just wanted to check with him to see if he wanted to be here for this or if he.
Okay, all right. All right. All right, sir, if you'll have a seat for a moment.
We're a quick study, Judge.
Just, what was that?
We're a quick study. We're ready.
Oh, you're, oh, okay, all right.
I had actually conferred with Mr. Griffiths, the prosecutor, this morning, so.
Oh, you did?
We're
Okay.
all on the same page.
All right, so Mr. Detonarski can come back. And, sir, you're before the court. Charge 1 is obscene communication using computer to seduce or solicit or lure. Number 2 is using a two-way communication device to facilitate a felony. Number 3, lewd or lascivious molestation, victim less than 12 years of age, offender 18 years or older. Number 4, transmit info harmful to minors. And based on I reviewed the affidavit to arrest, and I find probable cause. Also, the affidavit to arrest and the warrant to arrest. I reviewed those, okay? All right, so.
And regarding the bond, Your Honor, the charges that are listed at the jail are not complete. The paperwork is still going through. I've conferred with the prosecutor handling the case, Justin Griffith, about it. And because there are other charges not listed here, it doesn't make any sense to argue about the bond because.
There are other charges that are coming.
Yeah, basically what happened, Your Honor, is the state filed an information with 8 charges.
Okay.
But he wasn't, when he was arrested in Indiana, he was arrested on the arrest warrant. For all I know, we might not have even filed the information by that point. So he's gonna have to be served with the not in custody capias. That'll have the 8 counts, so.
All right.
So we'll take it up in front of Judge Merrigan.
All right, so we will leave the bonds in place that were attached with the warrant.
The only thing I'd be requesting, Your Honor, is in case he does, should Mr. Dudernowski, I apologize if I mispronounced, post his bond before, for some reason, BSO is able to serve him with the not in custody warrant, I'd ask that release conditions just no use of devices with internet access, no contact with minors.
All right.
You have no objection to that?
No contact with minors, no device with internet access. Do you understand that, sir?
Yes, I do.
All right. And so the $200,000 bond that's in place that will remain until.
Either it'll come through here or it'll go to.
No, it'll go to Judge Merrigan, and we're negotiating that.
Okay. All right, thank you.
Okay. I'll be over to see you, Mr. D. Tarnowski.
He's gonna come to see you.
All right, Wilmick Michelle.
He's here.
All right, Mr. Michelle is before the court on 2 traffic cases. These were issued both November 13th of this year on 2 different charges, operating without a valid license.
Judge, I'm speaking to Mr. Michelle. He wishes to resolve these matters today.
Okay.
One moment, Judge. No reason for that. Your Honor, on count 2, which appears to be the first, the earlier offense, it would be a withholding court cost. Count 2 would be an adjudication time served.
Judge, Mr. Michelle wishes to accept the state's offer.
All right, Mr. Michelle, please raise your right hand. Do you swear or affirm to tell the truth? Okay, sir, you can put your hand down. And do you understand the offer that has been extended to you? Is anyone forcing you to resolve your case?
No,
Are you under the influence of drugs or alcohol? Do you need any more time to speak with your attorney?
no.
You understand that you have the right to go to trial, but by taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand, sir, that if you are not a U.S. citizen, that by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, Mr. Michelle? Guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence on charge on the first KPS is withhold and court costs. Number 2, adjudication and time served. And you'll have court costs there as well, and you have 6 months to pay the court costs. Christopher Graves,
Medical reset.
Mr. Graves, a medical reset. Thank you.
You're welcome.
Avery Garland.
I've been advised to bond the judge.
All right, so Mr. Garland bonded, I find probable cause. Denzel Glasgow,
Paul, right?
all right, so Mr. Glasgow, you're before the court. These are now for additional charges.
Good morning, Your Honor.
Good morning, sir. Yes, all right, 16 through 21. And number 16 is 16 and 17, burglary, unoccupied conveyance, unarmed. Numbers 18 and 19, grand theft. Number 20 and number 21, fraud, use or possessing ID of another person without consent. So I find probable cause for these charges. And are any of the other charges burglary?
Yes, they are.
16 and 17, and the other standard bonds will remain, okay? Derek Matherly,
He's approaching Judge Yarborough.
Mr. Matherly is also before the court on additional charges, 3, 4, and 5. Number 3, grand theft. Number 5, dealing in stolen property. Number 4, dealing in stolen property. Number 5, false owner info for pawned items. And I find probable cause.
Judge, Mr. Mallory has been in custody. My understanding, he was being held on a felony offense. He resolved that felony matter, and he was given felony probation. He was, I believe, supposed to be released yesterday, and then these came up. My understanding is the current bond, which is set $8,000. There's no one that's going to be able to afford to post his bond. He's been here his whole life. He has work lined up. When he gets out, he's going to be working at People Ready. He's going to be living in Hallandale Beach with his mother. But Judge, considering he's going to be supervised on felony probation, I'm asking the court to consider an ROR on these offenses or releasing him on supervision on these offenses.
What is the nature of the other, the charges that he's been placed on
I
probation?
believe drug offense.
All right, right, I'm denying the ROR and I'm leaving the bonds in place at this time. Ricky D. Brewster,
Brewster, come on up, please.
Mr. Brewster is before the court. Charge 1 is fraud, attempting to use ID of another person without consent. Number 2 is grand theft. And I find probable cause.
Judge, we're gonna be asking for the court to consider releasing Mr. Brewster, ROR or under supervision. My understanding is, the date of offense, I believe, is, not recent. He was basically arrested for something similar to this about 9 months ago. He resolved his case. He was placed on community control. Right now, he is currently been supervised for the past 8 months, from what he advised me, with no sort of problems, no violations. He's been reporting every month. He's right now working. He's 57 years old. He lives in Timberley Apartments and works as a maintenance worker. And one of his benefits as far as working there gives him discount on rent. And that's where he's been living for the past 6 months. And he's paying about $800 a month. So, considering he's being supervised on a felony offense, Judge, he is on community control. That's why I'm asking an ROR on the alternative release and under supervision.
All right.
First off, I want to, Your Honor, the charges are booked correctly on count 1. It's actually not a new charge. Count 1 is criminal use of personal.
Okay. I can't hear anything.
Count 1 is criminal use of personal identification information over $5,000. That's a second-degree felony. And the grand theft is not from between $750 and $5,000. It's grand theft between $5,000 and $10,000. And to say he's on community control is one thing. To say that he was placed on 5 years community control for 6 separate cases, one for grand theft, another for criminal use of personal identification information, another for grand theft between $5,000 and $10,000, another for grand theft between $5,000 and $10,000, and 2 more for grand theft between $5,000 and $10,000, is adding a little more detail to the situation.
Well, I was waiting for everybody to speak. In this probable cause affidavit, it says that September 24th, he goes to Regions Bank and cashes a check from the victim's account for $8,695.11. And then there was further investigation on June 19th, the Coral Springs Regions Bank, where there is a total of almost $80,000 of similar checks belonging to the same victim in the cities of Green Acres and West Palm Beach, all cashed by the subject, Mr. Brewster. And so,
Judge, did the court say September of June of this year or which year?
2018.
2018.
Okay, that's okay.
all right, well, the booking report don't even, well, the probable cause affidavit don't even have, they have some warrant on there.
It's all happening at the same time.
It's the not in custody warrant that it's referring to, Your Honor. Capias, actually.
Okay. Criminal use of personal ID and grand theft.
Yeah, and that's why I said the specific amounts are not accurate as to what was actually filed.
Okay. All right, so Mr. Brewster has a total of $4,500 bond, and I'm leaving that in place.
In an abundance of caution, Your Honor, I'd ask for no victim contact with Oleg Pyrig.
No victim contact.
Thank
Nope, sorry. I don't have it, Mom.
All right, Arturo Montero.
North Broward.
Mr. Montero is before the court for an out-of-county felony hold. That's a no bond hold and not for magistrate. I guess that has already been addressed, right? In Orange County. And now he's before the court for, there's an at charge for an immigration hold, sir. And I've reviewed the detainer from Department of Homeland Security and find probable cause. You'll be held no bond to appear before an immigration judge shortly.
Mr. Montero wanted me to advise the court that he contends he finished his probation in Orange County.
All right,
And I wasn't able to verify that, so
Okay.
I can't verify it.
Honor, I did finish my probation on April 6th last year. I did everything that needed to be done. I even got filed the papers. I was in a hospital, mental hospital by the time I even did tell my PO at that minute. I don't know what's going on. I'm honestly really confused. I was on my way on a funeral. I was being done yesterday.
all right, well, you still have a no bond hold on the immigration matter, so, you'll have to, speak with your attorney. Somebody will have to make that determination on the Orange County matter, okay?
understand.
Leon
sorry.
Salters.
Sorry, Your Honor. I have not been able to make a call. I'm trying to make contact with my family. I just wanted if you let me allow to have a
That's
call.
something, you had a conversation with your attorney this morning. Did you tell him that?
No, because I was supposed
Okay,
to tell you.
so, you know, the jail now heard that you need to make a call, your attorney's now heard that you need to make a call, they'll take it from here, okay? Leon
you, Honor.
Salters. Mr. Salters is before the court. Charge one is burglary, dwelling or structure causing damage over $1,000. And number two is a misdemeanor KPS that was issued. It's a 2017 KPS for reckless driving. All right, I find probable cause.
Oh, Your Honor?
Yes.
I'm sorry, I pulled the information,
Yes.
and you can see, he was just charged with burglary of a dwelling, not a punishable by life offense.
All right. So burglary for dwelling is the only charge. All right.
That being said, I'm going to be requesting a $20,000 bond, pretrial release with a GPS monitor, no victim contact. Mr. Salters was released from state prison October 23rd of 2019. His history includes just out of Broward, see if he has anything outside of Broward. 2012 burglary of a dwelling and grand theft, 4-year state prison on a YO sentence. 2011 burglary of a dwelling, dealing in stolen property, grand theft. He received the same sentence. 2011 burglary of a dwelling and grand theft, same sentence. 2011 burglary of a dwelling, grand theft, same sentence. Hold on 1 second. 2011 another burglary dwelling. 2011 2 cases involving burglary of a dwelling and grand theft. Another burglary of a dwelling and grand theft in 2011. I'm showing, here I gotta check the court events, it might not still be pending. Out of Palm Beach County, he had a 2011 burglary of a dwelling that he was convicted of. In 2017 in Dade County, burglary of a dwelling, grand theft. I'm showing another case in Palm Beach County in 2017. It appears that's still open, Your Honor, because he has a status hearing January 3rd of 2020, and the charges are burglary of a dwelling, criminal mischief, grand theft, possession of burglary tools. He also has out of Martin County, it would appear, according to the clerk system, an open burglary of a dwelling and grand theft.
He's been in custody all this time, is that correct?
I'm showing,
This incident was from 2017, the incident date.
yeah, no, and I'm just trying to see,
He came in from Palm Beach, okay.
I can tell you. From what I can tell, DOC showing he was in custody from January 3rd, 2013 to December 29th, 2014. He might have had game time leading up to that. And then he was in custody March 1st, 2019 to October 23rd, 2019. That might have been for a violation of release conditions or game time. I'm not certain. He wasn't in Department of Corrections custody this entire time. Whether he was in other counties, I couldn't tell you.
Okay. All right.
Judge, and speaking of Mr. Sultry, he's been in custody since November 2017. As the state mentioned, he did finish serving a state sentence. He had other issues to take care of, but Broward came to pick him up, and now he's here, so he hasn't been released since then. Now, when he gets released, he's going to be living with his parents. My understanding is that they live here in Broward. His father works for a tow company, so his father actually has work lined up for Mr. Salters when he gets out. He's going to be working at his tow truck company. My understanding, Judge, is his parents support also his 5 younger siblings, and they're not going to be able to afford the monetary amount which the state has asked for. So that's, considering he's been in custody for quite some time, he's financially indigent, he hasn't been working. I'm going to be requesting a $2,000 bond on count 1, Judge.
Well, Mr. Salters has a lot of other things that are pending outside of Broward County. It's all the same kinds of charges. This charge, the allegations are that he broke into someone's home, stole estimated lost $2,400. And they were able to link this to him because they found DNA. There's just so much going on all over the place. I am going to impose a $10,000 bond, no victim contact, and no return to this location. And if Mr. Salters posts his bond, he's going to be on a level 2 pretrial supervision. Timnell Richey.
Mr. Richey, come on up, please. He's approaching, Judge.
Mr. Richey is before the court. Charge 1 is grand theft auto. Number 2 is possession of cocaine. I find probable cause.
Judge, my understanding is, Mr. Richey, this is his, he has a clean record. He's 23 years old, been living here in South Florida for the past 20 years. He's looking for employment. He lives with his grandmother. She does not work. So if the state can confirm he has a clean record, I'm going to be asking the court to first consider an ROR. If not, then I'm going to be requesting standard pretrial release for Mr. Richey.
Your Honor, he has no history. Your Honor, I would note, it does appear Mr. Richey has no residence, so no ability to provide a court notice to him. So if the court is inclined not to require a monetary bond, I would ask for pretrial It just adds an extra layer to make sure, ensure he appears in court, another resource he can inquire of to get his court dates.
Well, there's 3.4 grams of cocaine. There is 24 grams of 24.2 grams of marijuana. That's also found in cannabis is found in a jar. The tag that was on the car belonged to a trailer. And you're saying Mr. Richer has no permanent address?
No, he advised me he lives in Lauderdale Lakes with his grandmother, Judge.
All right.
Showing at large on both.
What? Well, did you say he had no priors, Mr. Linder?
He has no history, Your Honor.
Well, I am going to release him on a level 2 pretrial. They have to verify his address, as everything says that at large, it has no address on there. So I'll RR him to level 2 pretrial supervision.
Judge, what you
Yes.
could do, considering he has no prior, and if the court's concerned as far as where he's living, you could release him to standard pretrial upon verification.
No. Level 2 pretrial.
Okay, you're gonna have a monitor.
Yeah.
There's a cost, hours a day for it.
The pretrial, does he know the address so that we can update the records?
3081 Northwest 47th Terrace.
30
Lauderdale Lakes.
3081, what?
3081 47 Northwest apartment 108 Lauderdale Lakes.
47th what? Avenue, Street, Terrace, okay?
Yes.
And what's the zip code?
33313.
You said an apartment what?
Apartment complex.
What is the apartment number?
Oh, 108.
So 3081 Northwest 47th Terrace, apartment 108, Lauderdale Lakes, 33313. You got that?
Yes.
All right. Okay, D'Angelo Parks.
Come on up, sir.
Mr. Parks is before the court on one charge of carrying a concealed firearm. I find probable cause.
Judge, can we see if his bond's been posted?
Okay. Bond has been posted. Does Mr. Parks have any priors?
I'm not showing anything. David, do you have anything? I've got it. No, Judge.
It's a $1,000 bond. No weapons or firearms. Danny Jordan.
Mr. Jordan, come on up, please.
All right, Mr. Jordan is before the court for a violation of parole. It is a no bond hold, and so, sir, you'll have to appear before the parole board on this matter, okay?
Yes, sir.
Tyrell McCall.
Mr. McCall, come on up, please. Judge, he defined the service as a public defender. He's a
All right, Mr. McCall, do you understand that you are entitled to an attorney for this hearing?
Yes, Your Honor.
And you are declining the services of the Public Defender's Office this morning?
Yes, Your Honor.
And so you will be representing yourself at this hearing, is that correct?
Yes, Your Honor.
All right, you are before the court this morning. Charge 1, burglary on occupied conveyance unarmed. Number 2, illegal use of credit card more than 2 times in 6 months. Number 3, fraud, use or possess ID of another person without consent. Number 4 and number 5, burglary on occupied structure. No, number 4, burglary on occupied structure unarmed. Number 5, burglary on occupied conveyance unarmed. Number 6, grand theft. Number 7, illegal use of credit card two times in 6 months. Number 8, unlawful possessing personal ID of another. Number 9, fraud, use or possess ID of another person without consent. Number 10, petty theft. 11, felony violation of probation, that has a no bond hold. Number 12, burglary, unoccupied conveyance unarmed. Number 13, grand theft. Number 14, illegal use of credit card more than 2 times in 6 months. Number 15, unlawful possession of personal ID of another person. Number 16, fraud, use, possessing ID of another person without consent. 17, petty theft. 18, possess or receive or retain stolen credit or debit card. 19, illegal use of credit card 2 times or more in 6 months. Number 20, unlawful possession of personal ID of another. 21, fraud, use, possessing ID of another person without consent. Number 22, petty theft. All right, sir, there are several probable cause affidavits that are attached to these crimes that are alleged. I have read all of them. There are actually 1, 2, 3, 4, 5. I find probable cause for all these charges. All right, as to charges 1 and 5, I am going to impose a $5,000 bond. Number 12, a $5,000 bond. Numbers 12 and 13, $5,000 on each. 12, no, number 12, $5,000 bond. And number 13 already has $1,000, so we'll leave that. Okay, and then all the other bonds that are in place will remain in place. Looks like you have court on November 25th before your division judge on the violation of probation. Okay? All right, Louis Hodge. All right, Mr. Hodge is before the court. Charge 1 is battery on an officer or firefighter. Number 2 is disorderly conduct. Number 3, resisting officer without violence. Number 4, violation of felony probation. And that has a no bond hold, and it looks like your probation is before Judge McCarthy. You'll see Judge McCarthy on the 25th at 8:30 a.m.
And Judge, considering as a no bond hold on count 1, I'm going to be asking for a $1,000 bond on the third degree felony.
All right, I'll impose a $1,000 bond on charge 1. Okay. Ramon Wilkerson.
Come on up, Mr. Wilkerson.
Mr.
Judge,
Wilkerson.
he declined to serve as a public defender.
All right, Mr. Wilkerson, you're before the court on a, charge one is a traffic KPS and you have $100 bond there. And then I guess number two is that you were remanded into custody yes,
Yesterday.
yesterday? And so you have court tomorrow before that judge, okay? And that's a no bond hold, not for magistrate,
I mean, Monday, right? Okay.
okay? All right.
Yes.
Good luck, sir.
Ronald Doan,
Please approach, Judge.
Mr. Doan is before the court, one charge of failure to stop or remain at an accident. And number two is driving while license suspended. And I find probable cause. Does Mr. Doan have any priors?
Yes, one moment, Judge. Showing two prior DWIs out of the state of New York, which I do believe is a cause for concern considering the allegations in this case. I'm requesting a $3,500 bond on count one, Your Honor.
Judge, we're going to be requesting a $1,500 bond on Mr. Doan's behalf. He works in construction. He gets paid about $350 a week. Him and his girlfriend are raising his 13-year-old daughter. His girlfriend is going to be the one who posts his monetary bond. My understanding, she works walking dogs for a living. So he believes using the service of bondsman, she can probably come up for $1,500, and that's why we're asking for that monetary amount.
He struck somebody on their bicycle, they fell, hurt themselves, and then he leaves, and then he comes back and he says that he left because he's never been in a fender bender. All right, $2,500 bond on one. Alnick Joseph.
Mr. Joseph, come on up, please.
Mr. Joseph is before the court. Charge one is fraud, misrepresent self with a personal ID. Number two is grand theft. Number three is larceny of a credit card. And I find probable cause.
Mr. Joseph told me he's not going to be able to afford to post bond. Judge, he's asking for the court to release him on pretrial release. Now he is working. He's been working for the same company for 5 years. It's called Fresh Point Produce. He does basically packaging. He makes about $15 an hour. He lives in Lauderhill in an apartment by himself. He's 36 years old. From what he advised me, Judge, he pays child support $207 a month. My understanding is the prior contact with the criminal justice system, but it's been about a year. So he's asking to be released on pretrial release.
I don't have an objection to pretrial, Judge. His, just so the court's aware, his only theft-related prior was from like 2001.
Regard to pretrial supervision, Mr. Joseph, you need to go to the pretrial office. Today's Friday, so if you don't get out in time to get over there, you'll have to be there by Monday morning. And if you don't report, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
All right.
It's for you, it's Peter Bonbon.
Selvin Soto,
Please approach him, Judge.
all right, Mr. Soto is before the court on one charge of aggravated battery with a deadly weapon, and I find probable cause.
Judge, my understanding, this is Mr. Soto's first contact as an adult with the criminal justice system. He's 19 years old. He has prior contact as a juvenile, but he's been here his whole life. He works off and on doing roofing. On a good week, when there's work, he says he can make up to $300 a week. He lives in Pompano Beach with his mother in a trailer where they rent. She works. From what he advised me, she cleans houses for a living. He advised me the most she can probably afford using services of bondsman is $3,000, and that's also going to probably be a financial struggle for her. But that's what we're asking for, Judge.
What are you asking for? I'm sorry.
Oh, $3,000.
Okay.
Your Honor, the court should be aware that a different individual just a month ago in Broward, I won't name her, but she sought and obtained a temporary injunction order of protection against Mr. Soto. It is in place until December 10th of this year. Now he's before the court with an allegation that because the victim wouldn't give him beer, he got into a fight with him and ultimately stabbed him. This was corroborated by the witness to the incident. I'd be requesting a $7,500 bond and no victim contact.
Well, what the probable cause affidavit says is that, he challenged Lopez to fight. Lopez accepted the request.
Yeah, no,
You know, I don't, you know.
I agree that they mutually got in, they mutually entered into a fight. Mr. Soto escalated it. I would note the allegation is that he was, one moment, Lex. There was an escalation. Mr. Soto introduced the knife into the situation, and then.
Well, it
I
also
was not-
says that as Soto was lying on his back, Lopez straddled Solo and began to punch him. Soto then pulled a knife from his waistband and stabbed Soto.
Well, if you accept a challenge to a fist fight, you know.
You shouldn't bring a knife to a fist fight.
Well,
is that
well,
what you're saying?
you shouldn't, but you know.
Still, it does sound like a mutual combat thing. You know, obviously, we weren't there, but it does appear that Mr. Soto did not produce the knife until Mr. Lopez was on top of him and punching him.
Yeah, but the fact still remains that it was a challenge to fight. So, you know.
No, I understand what you're saying. But
All right, I am going to impose a $3,500 bond. No victim contact. And no victim contact means no phone calls, no text messages, no social media, no third-party contact. Do you understand that, Mr. Soto?
Yes, Your Honor.
All right. Romeo Paul,
He's a North Broward, but
North Route.
Yeah, he refused, Your Honor. He says he'll try and make it tomorrow.
oh, really? You know,
Just
what
let
do
him know,
you
Deputy.
have
We'll try
going
not
on
to
up there, Deputy?
inconvenience him.
what do you have for room service for breakfast?
You know, I had the other one respectfully deny,
I was gonna say,
he'll try and see if he can make it
I
tomorrow.
was gonna say, Deputy, if you can, give us the times when he's available, we'll try to.
I know, well,
Try to
well,
accommodate him.
Exactly.
we'll reset for tomorrow and see what happens. Colby Alford. So they know while they're refusing, they have no bond. Colby Alford.
He's here, Judge.
Mr. Alford is before the court, charge 1, resisting without violence. Number 2 is a violation of felony probation. Number 3 is also a violation of felony community control. I find probable cause. The 2 and 3 have no bond holds. And you will see your division judge on Monday at 8:30 a.m. And you have a $100 bond on number 1, okay? John Beeston.
Come on up, sir. He's approaching, Judge. You're at me.
All right, Mr. Beeston has 1 charge of possession of cocaine. And I find probable cause.
Judge, my understanding is Mr. Beeson, he's financially indigent. He is homeless. He gets disability. He's been living here in our community for almost 20 years now. My understanding, Judge, is he has prior contact with the criminal justice system. He was state sentenced. I believe he got out of a state detention back in 2006 from what he advised me, and since then he's had a clean record. So he's asking to be released on this nonviolent offense on pretrial release, Judge.
Your Honor, I am showing he got an NTA a week ago for a theft at a Publix in Oakland Park.
Has any other priors?
He does. They are dated.
All right.
Actually, I'm sorry. He has an open theft out of Palm Beach County as well. That was let's see. That was from a few days ago, about a week ago. Everything else is dated.
It's from Palm Beach. It's a misdemeanor?
They're both, the Broward and Palm Beach are both misdemeanor thefts.
But they're all recent. Is that what you're saying?
I'm sorry?
How recent?
Oh, the Broward is November 14th. The Palm Beach is indicating, one moment. Under the progress docket on the clerk system, it indicates the probable cause affidavit was put into the system November 18th.
Mr. Beeson has a $1,000 bond. I'm going to leave that in place. Eric Roberts.
North Broward, I believe.
All right, do we have Eric Roberts? North Broward? Someone else respectfully declined to appear.
Sheila, should he have been taken off the docket?
There's a grand theft charge, I mean, among all the capuses, and there's a, number 13 is a grand theft charge.
It's like it's like a Where's Waldo.
Number 13.
Why they put it at 13, like surrounded by?
Yeah, it's surrounded by a lot of VOPs, and then number 13 is a grand theft charge. All right, so. Okay, all right, so we'll see Mr. Roberts. We're not sure if he'll be for the afternoon or for tomorrow? Okay. All right, so we'll reset for this afternoon and then we'll see what happens. James Fonseca.
Paul Ryan, Your Honor.
Mr. Fonseca is before the court. Charge 1 is possession of cocaine. Number 2 is possession of drug paraphernalia, and I find probable cause.
Showing. Drug paraphernalia pled out a couple months ago with the trespass. Theft from last year that was pled out January this year. Trespass last year. Possession of cocaine and tampering with evidence 2016. Possession of cocaine 2015. Possession of cocaine 203. Those are his Broward priors.
Okay. Is Mr. Fonseca who's to be heard, Mr. Reader?
Yes, Judge. Do you have a place to stay, Mr. Fonseca?
No, at the moment I'm on the streets. But I was gonna go into the shelter, Broward Outreach.
Is that where you would go if you were released?
Yeah, that's a.
Yeah.
If you see the allegations, he was in the park when this incident occurred, so.
Do you
I
have
was
any,
going to Broward Outreach, so you guys were supposed to release me.
do you have any money to post a bond?
No, sir.
Do you have any family or friends who could post a bond for you?
No, sir.
There's no one I can call?
No.
Mr. Fonseca, I'm gonna release you to pretrial supervision, sir. What that means is the deputy is going to give you the information for the pretrial office. You're up at the north facility, so, by Monday morning, you need to report to the pretrial office. If you don't report, a warrant is going to be issued for your arrest.
All right.
Also, as part of your pretrial supervision, you will be subjected to random drug testing. Do you understand that?
I understand.
All right.
Yes. The only other thing I'd ask if you could instruct Mr. Fonseca as to his responsibility with respect to.
All right, so, Mr. Fonseca, I'm releasing you. You will, once you sign up, you will have access to pretrial supervision. You also have an attorney from the public defender's office. Because you don't have an address, it is going to be your responsibility to check with either of those persons or to go online and check with the clerk's office so that you'll know when you have to come back to court. Do you understand that?
All right, man. All right, man.
Okay. James Silva.
I think we did this yesterday?
I was wondering, I wasn't sure. It was a reset from yesterday? And
We did them.
She said something that I'll be back today because something was messed up, the wrong chargers or something. That's what she said yesterday.
To the best of my recollection, I believe count one was an error. I believe he has a Dade County hold.
Hector, confinement status was just about to advise the judge.
Okay, go.
Go ahead, Sheila.
Okay.
Judge, he was reset because they had booked him in on a grant that should have not been placed on him. So I believe when he finally
All right, so the grand theft has been dismissed? All right, so that shouldn't be there, and there should be no bond hold.
And Your Honor,
Okay.
if I may, just to clarify,
It
Sheila,
did
does
say
he-
not for magistrate, whatever it was.
does he still have a Dade, does he still have a Dade County hold, or has that been taken off?
Yes. Yes, I do.
Okay.
Oh, they're looking.
So 2 and 3 then are, number 2 is dealing in stolen property, and number 3 is false owner info for pond items.
I want to find out what items. I need to know nothing about my items. Don't talk about the fact. Okay.
Now I
All right,
remember,
so,
Your
so
Honor.
that court order was, that he was brought from another county, what?
Yeah,
This
Judge,
Dave.
he did come in from Dade County and he came in home for Dade County. But when our transportation union brought him in, she put that grant theft on there as error.
So my question is, so now my determination form has that court order that says no bond.
It should have said, and you can talk to her.
Okay, because all right.
Your Honor, if I recall, what we were advised yesterday was unfortunately they could not get Mr. Silva in front of Judge Weeks on the date that was listed in the order, so I believe she reset it for a December date.
Okay.
In light of all that, Your Honor, I would just request that the listed bonds be kept in place.
Okay. All right, so we took off the grand theft. Is no bond required on that court order, and then 2 and 3. All right, so we'll leave $3,500 and $1,000 on 3. Okay, so there's a total of $4,500 in bond. Okay, all right. John Isma,
Medical research, Judge.
medical reset, and then Mark Johnson.
Medical loan, Judge?
Mr. Johnson is on medical loan. All right. All right, then, thank you, everyone, and we'll see you this afternoon.
Sounds good.
Thank you for not declining the invitation to be here.